What's up, everybody, and welcome back. For those of you that were on our previous live, we're redirected right into Bryan Kohberger's change of venue. It has been granted, but not just that, this judge is gone. And at the end of the video, we're going to find out exactly how the Gonsalves family, one of the victims' families, feels about the change of venue and about Judge, who's no longer on this case. And that's one of the most interesting parts about this. But he gives us his reasoning as to why he changed the venue. And I think it's going to be interesting for us to look into and dig into and see if we agree with it. So make sure you guys get ready for this one. Hit the like button. Make sure you subscribe. Let's jump into this document. So we know this case well enough, right, folks? We don't need to go through the introduction and we don't need to go through the background. We have read the motions. We have watched the hearing. We know how everything was presented, but what we don't know is what the judge thinks about this. And this document goes through how the judge viewed the evidence, how he looks at it, how he looks at the law and analyzes it, how he marries the facts and the expert testimony and the law and comes to his decision. We know a lot's been going on in this case. Nonstop, fast and furious, extra hearings. I keep telling you, this is happening way faster than any other case. Every time, not the totality of it. The totality of it now is kind of on a normal track, but every time they have a motion, boom, we're having a hearing on it right away. The judge is going to make some kind of emergency decision. Things in camera, under seal, sealing something, unsealing something, nonstop. And just remember that when we get to the end of this video. So let's begin. As noted above, at the change of venue hearing, Kohberger presented expert testimony from James Todd Murphy, Dr. Amani El Alayi, Dr. Bryan Edelman, and Dr. Veronica Dar. Additionally, Kohberger submitted several exhibits depicting news stories, news clips, and social media posts for this court's review. The state did not call any witnesses or submit any evidence. That I found to be an interesting line. Did the court think the state punted this? That the state knew they were going to lose, or maybe even agreed that they should change venue? I don't know. The court will summarize the key takeaways from the testimony offered by each of Kohberger's experts. First, Murphy. He's the president of TrueScope. This seems like a lawyer you know video here. He's just going to summarize the testimony here. TrueScope provides media monitoring services that offer information to help understand the impact of media coverage on a particular community. TrueScope looks only at mainstream media sources such as newspaper and news stations. Of the mainstream media coverage in Idaho of this case, 36% of that coverage has been within Latah County. This would include media like the Moscow Pullman Daily News, Lewiston Tribune, and the television news station out of Spokane, Washington. Kohberger requests this case to be moved to Ada County, which has 34% of the mainstream media coverage in Idaho. While the media coverage percentages are similar between the two counties, Ada County has a much larger population than Latah County. You notice how the comparison is the important part. And that's the part I thought the state should have attacked a little more. They did a good job picking at it, but that's really the big deal to me, is the comparison between Latah and wherever it's going to move. Will it be in Ada County? We'll see. According to Murphy, this means that the media coverage in Ada County is much more diluted, while Latah County is saturated with such coverage. Stated differently, media coverage in Latah County offer twice as many opportunities to be seen per person than in Ada County. The higher volume of coverage in Latah County, coupled with the smaller pool of eligible jurors, means people in Latah County had twice as many chances to be exposed to this case versus those residing in Ada County. When looking at the volume of media coverage over time, Ada County had a higher volume of media coverage from February of 23 to June of 23. However, since that time, Latah County has consistently had the higher volume of media coverage, with the two counties being similar overall in the current coverage of this case. All of this taken together means that the probability of Latah County resident being exposed to media coverage of the case is much higher than the probability of an Ada County resident being exposed to media coverage of the case. And we'll remember, and you'll recall from other orders, the judge recapping the testimony or the evidence does not necessarily mean that's how the judge sees it, but this is how the person testified to it. See if we have any questions here. Can't wait to hear the insights from Pablo Escobar. Yes, that's my expertise. Why is there a new judge, Midwest? Oh, we're going to talk about that at the end. I found that to be the most interesting part of this. because I kind of expected, I wasn't sure, but I expected a change of venue was probable. I did not expect a change of judge. Dr. El Alali. Dr. L is a social psychologist and social cognition researcher. As part of her research, she evaluates how publicity about a case can shape potential jurors' attitudes. It's important for this case. She found that the more likely the potential jurors are to dislike the defendant and view the defendant as guilty, the more publicity there is. She believes the publicity in Latah County has been exposed to makes them biased against Bryan Kohberger for several reasons, even if the bias is subconscious. First, Latah County authorities figures publicly spoken about Kohberger's guilt. Former police chief James Fry was the police chief during the investigation of the homicides, publicly declared he had no doubt they got the right guy and had been arrested for the crimes. After Kohberger's arrest, the University of Idaho president stated publicly that the university community once again feels safe. Generally speaking, individuals are more likely to trust and believe authority figures, so these statements by Latah County authority figures are particularly impactful to Latah County residents, especially versus other counties that don't hold these figures maybe in the same authority that Latah County would. Second, because Latah is a small county, close-knit community members feel a sense of loyalty to community views and fellow community members. For example, Latah County jurors may feel an inner clash of conflict if they felt the state had not proven Bryan Kohberger guilty beyond a reasonable doubt, because they may feel voting guilty would not cause community outrage or, once again, cause fear within the community. Thus, the inner clash may cause jurors to vote guilty even when they believe there's a reasonable doubt as to guilt. This inner clash may be even greater when personal connections with Latah County are considered, i.e. my neighbor who is a police officer may be upset with me if I don't vote guilty. And again, this is not judge's view. This is how the testimony was presented. Similarly, given the small size of Latah County residents had a much more emotional experience surrounding the homicides and therefore are much more invested in the case. For example, when Kohberger was arrested, Latah County residents who had been fearful experienced a sense of relief, which equates to believing Kohberger is guilty. Next, the extensive negative publicity surrounding Kohberger leads potential jurors to think of Kohberger negatively. Stated differently, before Kohberger's arrest, if one was to hear the name Bryan Kohberger, the reaction would have been neutral. Now, after Kohberger's name and picture has been associated with terms like murder, evil, killer, stalker, when individuals hear the name, it's a negative association. I agree with that. This impact is greater in Latah County because of the saturation of the extensive media coverage. Finally, given all this, the doctor opined that it was arguably impossible for residents of Latah County to be asked to serve as impartial jurors because they are biased against Mr. Kohberger, even if they do not want to be biased or think they are biased. This is particularly difficult for the defense to overcome because when humans process information while experiencing emotions like fear and anger, it is difficult to change the opinions formed even in the face of contradictory evidence. Instead, he was, as humans pay greater attention to information that backs up our initial preconceived ideas and opinions. Taken together, Dr. E stated, her opinion, the best way to ensure Kohberger's trial by a fair and impartial jury was find jurors who are both physically and psychologically removed from Latah County. Again, a little bit of a recap. No surprise, but that's how he sums up the testimony of Dr. L. All right, Edelman, we know about him. He surveyed Latah County residents. The key findings from the survey show that the case recognition is high in throughout Idaho. 98% in Latah County recognize the case, 93% in Ada County, 90% Canyon County, 84% in Bannock County. Latah County, 98% of the respondents that recognized the case, 67% thought he was guilty, 24% said they believed he was definitely guilty. Similar in Ada County, 68%. 22% said definitely guilty, 69% in Canyon, 23%. So all very similar. 76 in Bannock, 19%, so a little lower there. In Latah County, 51% of the respondents reported Kohberger would have a difficult time convincing them he is not guilty. Percentage of respondents who reported that Kohberger would have a difficult time convincing them he's not guilty was actually higher in other counties, 56% in Ada, 57 in Canyon, and 53 in Bannock. So Latah was actually the lowest. But again, with how small Latah County is, that's how they're applying the standard. Now, is it true? Is it not? Again, I said during the hearing and when this testimony was originally presented, it's like, yeah, we deal with this in literally every case with criminal defendants. Like people normally think they're guilty. So what makes this different? The level of media attention specifically is what they're talking to about. And honestly, the survey just gives us answers we already know a lot of time, but It's very interesting. Piney, it's my opinion, given the information that's been released, that the state doesn't have the requisite evidence to convict. Not enough, in my humble opinion. Well, we don't know everything the state's going to present yet. So again, that's why we're completely open, waiting to trial, but 100% right. He's presumed innocent until we go to trial. As a fellow Tesla guy, have you reviewed the new FSD 12.5 or the summons feature? Not an important question. Had to ask, maybe save for last. John, I'm gonna hold this and I'm gonna answer it at the end. Peter, Mario Bros. Halloween costume this year. Thank you for your continuous insight. I don't know what I'm gonna be for Halloween. What will happen to being streamed if not on Judge's channel? Will they now file a streaming of the trial again? That's gonna be up to the new judge. Those are gonna be motions filed in front of the new judge. And does the defense want cameras now? Because remember, they wanted certain things unsealed. They wanted the protections of it. The state definitely doesn't want it. But will the defense want it now? Because before, they both didn't want it. Nancy, Peter, is it going where the Daybell trial was? And if get that judge deserves extra therapy, although sadly, this isn't bad compared to the Daybells. So hold. Because the answer is I don't know yet to this question. All right. 51% felt death penalty was appropriate. 23% felt life in Latah. Ada County, 49%. 57% in Canyon. 53% in Bannock, all thought death penalty. 29% in Latah County followed the case very closely. In Ada County, 58% said they followed it very closely, while the number fell to 51% in Canyon and 46 in Bannock. So again, Ada had the highest one. Biggest city, biggest county. But like, again, if I'm looking at these numbers, it's not a black and white decision. It's not obvious. It's not guaranteed. That's why I said I think he's going to change venue, but I'm not confident in that guess. 39% of the survey respondents in Latah County indicated they experienced high levels of stress, anxiety, or fear during the search for the person responsible for the killings. This contrasts with 17% Ada County, who answered yes to that question, 11 in Canyon, 11 in Bannock. So that's a pretty big difference because they're actually personally connected to it based on where they live. Addition doesn't mean they're not consuming it in other places, right? Just like I am here in Florida and you may be in Australia or the UK or anywhere around the world. Additionally, a higher number of Latah County residents reported talking about the case with others living in Moscow when the homicide occurred, having ties to the University of Idaho and having ties to law enforcement who investigated the crimes. Finally, Edelman considered the population size. Ada County is 400,000, Canyon County 186,000, Bannock County 66,000, Latah County 32,000. So obviously Ada by far the biggest, 10 times bigger, more than that, than Latah County. Based on all the information obtained from the surveys, Dr. Edelman opined that case recognition and presumption of guilt is and will continue to be high throughout Idaho. Given the extensive media coverage the case has generated, in his opinion, population size matters. For example, if roughly 50% of Latah County residents presume Kohberger is guilty, that leaves approximately 15,000 Latah County residents who do not hold this presumption. If those, not all will be eligible to serve as jurors. In contrast, if 50% of Ada County presume Kohberger is guilty, that leaves 200,000 residents who do not hold such a presumption. Thus, Ada County has a much larger pool of non-biased jurors. So that's really, I think, what it came down to Judge, comparing 15,000 to potentially 200,000 if it ends up in Ada County. That's a big difference of potentially unbiased jurors. Doesn't mean they're going to be unbiased. Doesn't guarantee they're going to be unbiased. And again, this doesn't take out the people that don't just have months to sit here on a jury, like certain jobs or family requirements, or they're connected to a witness in the case they didn't know about, whatever it may be. There are people that are struck or let go in every trial every day that don't admit that they have such a bias. So these numbers are going to come down drastically. And obviously, they're not going to call 200,000 jurors to come for this case anyway. Even more important to Dr. Edelman, though, was the issue of personal connections within Latah County and the personal impact this case has had on Latah County residents. The feelings of fear, stress, anxiety surrounding the homicides were significantly greater in Latah County than in other counties. This also was true for the connections to the University of Idaho and local law enforcement. Dr. Edelman testified that these connections and experiences are the real issue when it comes to seating an impartial jury in Latah County. Based on the results of this survey, Dr. Edelman opined that in his expert opinion, there is a reasonable likelihood the presumption of guilt prevails in Latah County and the change of venue is appropriate. Veronica Dar. She was called to talk about the validity of the survey. She testified the surveys were conducted in accordance with applicable standards and results are sound. Media articles and video clips. Again, this is him summarizing all the evidence. This was part of the evidence. We didn't get to see a lot of it, but we have seen a lot of it, right? Maybe we were even a part of it. The defense also submitted numerous media articles and video clips demonstrating the sheer volume of coverage that this case has generated. The court agrees, and the state does not dispute that coverage of this case by both mainstream media and social media outlets has been extensive in Latah County, throughout Idaho, and nationally. While some of the mainstream media reporting has been appropriate and based on information from the court record, there has been extensive coverage that is prejudicial to Kohberger and likely inadmissible at trial. Not the coverage, but what they're talking about in the media coverage. All right, let's get to the standard. Both Idaho Constitution and U.S. Constitution protect the defendant's right to a fair trial by impartial jury. To help achieve a constitutionally sound trial, Idaho Court Rule 21 allows a transfer of a case for trial in certain instances. Idaho Criminal Rule 21A states that on motion of either party, the court must transfer the proceeding to another county if the court is satisfied that a fair and impartial trial cannot be held in the county where the case is pending. Similarly, this Idaho rule states that criminal action prosecuted by indictment may be removed from the county in which it is pending on the application of the defendant on the ground that a fair trial and impartial trial cannot be had in the county where the indictment is pending. Another Idaho rule says on motion of the defendant, the court may transfer the proceeding to another county for the convenience of the parties and witnesses and in the interest of justice. Certainly ain't going to be convenient for the parties and the witnesses, right? For the lawyers, for the witnesses, and even the victims' families, they're going to have to drive hours away wherever this ends up, stay in hotels, leave their life and their jobs and their families, even more so than they were expecting to. They can't just drive back home at night. They can't be around their support system potentially at night. Huge inconvenience for witnesses, victims, and lawyers. Now, it's not going to happen every hearing and every time we have a court date. A lot of that's going to be able to have by Zoom would be my guess, and absolutely how it should be to keep it fair. But when the trial happens, you're going to have to be there. The victims don't have to be there, but I assume they want to be there. A motion for change of venue pursuant to Idaho Criminal Rule 21 is left to the discretion of the court. That means unless he's way off and abuses his discretion, whatever he decides is probably going to go. And this is not something that usually wins on appeal, regardless of which side you're on appealing it. Prejudice. In deciding a motion for change of venue, the court determines whether in the totality of the circumstances, juror exposure to pretrial publicity will result in a trial that is not fundamentally fair. The critical inquiry is whether the nature of their exposure to pretrial publicity caused the prospective juror to form an opinion about the defendant's guilt, and as a result, they are unable to serve as an unbiased juror. In determining whether a criminal defendant actually received a fair trial, the Idaho Supreme Court considers the following factors. And here are the factors the court's going to go through in his analysis. Number one, the existence of affidavits indicating prejudice or an abuse of prejudice in the community where the trial took place. Number two, the testimony of the jurors at jury selection regarding whether they had formed an opinion based upon adverse pretrial publicity. So you're seeing how normally this happens after you've tried to pick a jury and failed, or you've had a trial and it ended in a mistrial. Whether the defendant challenged for cause any of the jurors finally selected. Number four, the nature and content of pretrial publicity. And number five, the amount of time elapsed between pretrial publicity and the trial. Some of these factors can only be evaluated during or after jury selection, while others can be evaluated by the trial court in deciding an earlier motion to change venue. So you're going to see what factors the court actually uses and why they're different than these, because we haven't tried to pick a jury. We haven't already had a trial. Actual prejudice. In evaluating juror prejudice, the relevant question is not whether the community remembered the case, but whether the jurors at trial had such fixed opinions that they would not judge impartially the guilt of the defendant. Stated differently, courts must evaluate whether in the totality of the existing circumstances, juror exposure to pretrial publicity resulted in a trial that was not fundamentally fair. The defendant bears the burden of proving prejudice or showing a reasonable likelihood that there was prejudice. Hence the reason the defense called witnesses and presented evidence in this hearing. In reviewing the case law, a finding of actual juror prejudice rests on an examination of the jury selection process. This includes evaluating how jurors answered screening questionnaires, the testimony during voir dire, and the venire as a whole, and the jurors eventually seated, and any seated despite a for-cause challenge by the defense. In reviewing a trial court's decision denying a change of venue, the Idaho Supreme Court considered the testimony of the jurors at jury selection regarding whether they had formed an opinion based on adverse pretrial publicity, whether the defendant challenged for cause any of the jurors finally selected. The factors are considered along with the evaluating the pretrial publicity itself and the timing of the publicity. Here, the defense argues that the survey work of Dr. Edelman establishes actual prejudice within Latah County. However, actual prejudice cannot be evaluated at this juncture based on a survey of 400 Latah County residents who are anonymous, who did not answer questions of the court and were not subject to questions by the state. Without attempting to seat a jury, there's no real evidence, such as juror screening questionnaires and testimony during voir dire, for this court to evaluate actual prejudice. So no actual prejudice seems like the defense is going to lose, right? That's what it seems like. It seems like he's throwing out Dr. Edelman's survey, right? It's not going to prove actual prejudice, but what about presumed prejudice? Adverse publicity can create such a presumption of prejudice in a community that the jurors' claims that they can be impartial should not be believed. So this is always, people are going to take offense to this if he says, I can't believe you if you tell me you're going to be fair and impartial. But how does that change going from Latah to Ada or any other county? Well, maybe it doesn't. And that's why we have to remember the prior statements of fact the judge made, where even if he's saying, some people just can't realize they're not going to be fair and impartial, even if they say they are. So he's not believing certain people, but even the people that are fair and impartial based on the survey is 15,000 in Latah, 200,000 in Ada County. A presumption of prejudice only attends in extreme cases, and juror exposure to news accounts of the crime alone does not presumptively deprive the defendant of due process. Publicity itself does not require a change of venue. Prominence does not necessarily produce prejudice or juror impartiality. It does not require ignorance. Unlike the actual prejudice, a finding of presumed prejudice means that the court need not consider juror screening questionnaires or testimony during voir dire before declaring a jury verdict void, or in this case, declaring a change of venue appropriate based on prejudice. It is the defendant's burden to establish a reasonable likelihood of prejudicial news coverage prevented or will prevent a fair trial in violation of the Sixth Amendment to the United States Constitution. This is not an unreasonably high hurdle for a defendant to clear. Interesting. Now he starts throwing this language in. Now we start to see maybe it's going the other way. In cases where juror prejudice has been presumed, the following factors have been examined: the size and characteristics of the community in which the crime occurred. Number two, the news stories contained a confession or otherly blatantly prejudicial information of the type of readers or viewers could not reasonably be expected to shut from sight. Three, the lapse of time between prejudicial news coverage and the trial, and what the jury actually found as far as guilt is concerned. In Idaho, courts consider one, the existence of affidavits, the nature and content of pretrial publicity. Okay, we already reviewed that. First, as to the size and characteristics of the community. Before we get to these elements, let me answer a couple questions. Court TV's coverage said that the judge would stay on the case. Well, hold your horses. We're going to read it here from the horse's mouth. Okay. A couple of these are just off topic, so I'll just keep reading here. Okay. First, as to the size and characteristics of the community. Latah is relatively small, with a population of 41,000. State argues this is enough to impanel 18 impartial jurors. Defense argues that small, tight-knit community makes it impossible. Latah County residents have been exposed to the emotional experience and feelings of fear residents experience in the wake of the homicides, feeling of loyalty to the community and community connections. Defense's position is supported by the testimony of Murphy, L. Ayali, and Dr. Edelman. As Murphy testified, 36% of all mainstream news coverage of this case throughout Latah County, coupled with the smaller populations. Edelman's survey results. Okay, we already read all that. Great concern over the emotional experiences by Dr. L. All right, so we just recapped the expert testimony there. Next, as discussed above, it is undisputed that there has been significant media coverage in this case throughout the state. While some of the coverage has been neutral, hopefully he's talking about us there, of the court proceedings, much of the coverage has been sensationalized and prejudicial to Kohberger. By way of example, the defense presided the court with 1,222 pages of news articles covering the case from one local newspaper. One article published after Kohberger's arrest includes a statement from Washington State University students who reported feeling weird having sat in class with Kohberger and felt relieved knowing Kohberger had been arrested. Another article starts out by referring to Kohberger as the man accused of slaughtering the University of Idaho students. The title of yet another article, The UI Killer. While the issue of the extensive sensationalized coverage is not unique to Latah County, it is potentially more impactful given the volume of coverage coupled with a smaller population, covered with the connection to the community, right? I just tried to wipe my screen because that spot, but it's just there. As to the lapse of time between the coverage and trial, the information provided by Mr. Murphy demonstrates that coverage has overall waned since February of 2023. However, there is an uptick in coverage before and after the hearings and the court decisions. This is especially true for Latah County. With Ada County following a similar trajectory, the court does not anticipate this trend will continue leading up to trial and anticipates that coverage will substantially increase in the weeks and days before the trial. He's right about that. Finally, while the court does not have affidavits demonstrating prejudice, the court must consider the results of the surveys from Dr. Edelman. So he is considering the results. Again, while the presumption of guilt was similar across all counties and surveyed, the number is more impactful in Latah County given the smaller population. 67% thought he was guilty. 51% said it'd be hard for him to convince them of his innocence. While similar percentages were the same in Ada County, the impact of these numbers were considered when considering the population size are drastically different. 24,000 residents, 12,000 fair. We talked about that. And how many 10 times more for Ada County. Thus, when considering the prejudice to Latah County demonstrated by Dr. Edelman's survey and the population size of Latah County together, the court is concerned that if venue is not changed now, it will likely be asked to reconsider his decision during jury selection, which, if granted at that junction, would very likely result in the trial being delayed many months. So we talked about how this court has not wanted to delay this trial. He's tried to make quicker decisions and push things along and done everything he can to move this case along, which I think he has moved this case along. And that's one of the reasons he's making the decision to move it now, because he thinks I'm probably going to have to move it later. And if I move it later, then we got a big problem. Considering the undisputed evidence presented by the defense, the extreme nature of the news coverage in this case, and the smaller population in Latah County, the defense has met the rather low standard of demonstrating a reasonable likelihood that prejudicial news coverage will compromise a fair trial in Latah County. Thus, the court will grant Kohberger's motion to change venue for presumed prejudice. The court will grant Kohberger's motion to change venue for presumed prejudice, not actual prejudice, but presumed prejudice. Because of the media coverage that's basically slanted against him for the most part, and it's equally prevalent in Latah County as it is with bigger counties, but because of the smaller number, connection to the university, connection to the victims, connection to the community, more scared at the time, more happy when he was, off the street and they got the guy, more statements from authority figures like the police chief, the Idaho president, prosecutors in Latah County, all of that combined with that connection is presumed prejudice. That's what the judge has determined to boil it all down into a 30-second summary. But there's more. There's more considerations the judge made. And we heard about this and we talked about this, and I just mentioned it before, how inconvenient this is going to be. But what about the convenience and interest of justice for all of those involved, that it's their job? Even without a finding of presumed prejudice, venue in this case must be changed for the convenience of parties and witnesses and in the interest of justice. That's interesting. While the issue was summarily addressed by the parties, the court has considered the logistics while the motion for change venue was pending. While Latah County court staff and court security are ready and willing to facilitate this trial to the best of their ability, there are serious issues that cannot be resolved no matter how much planning and preparation is done. So I want to, before we go into this, and I think some people might hammer Judge for this. Oh, he's saying they can't do it. He's not even giving them a chance. This is their responsibility. They're professionals. This is his courthouse. He works here. He works with these people. He knows these people. My guess is he's talked to these people. So let's remember that when we read through it. I think he's trying to make the best decision for everybody. I really do. Doesn't mean we have to agree with it. Or doesn't mean you have to agree with it or I have to agree with it. First, and perhaps most important, is the issue of safety and security for the parties, witnesses, victims, families, jurors, and Latah County community. The Latah County Sheriff's Office, which is currently fully staffed, simply lacks the number of officers needed to provide security for the trial while also continuing to perform their day-to-day duties of patrol and responding to calls. One solution is to ask the Idaho State Police and the Moscow Police Department to help. However, officers from the ISP and MPD were heavily involved with the investigation, the homicides, And it is anticipated that several officers will be called to testify at trial. Additionally, it is the court's understanding that both these agencies currently are understaffed. So while Latah County is staffed, those two are not. Pulling local officers away from their normal duties for 3 months to provide trial security would potentially put the Latah County community at risk. Further, in the event of a natural disaster, such as a wildfire or a large emergency, like an active shooter or multi-level car wreck, there is a very real possibility the officers would be tasked with trial security would be pulled away to deal with the other issues. Thus, while our local law enforcement is ready and willing to do what they need to do to ensure a safe trial, there are not enough officers to ensure the safety of the parties, witnesses, victims, families, jurors, and community for a 3-month period. I don't think he's taking shots. I think he's trying to be realistic, and I think he realistically doesn't think this is going to work. I don't know. I don't have any experience there. I'm not from Idaho, never been. Would love to go. Here it's beautiful. But yeah, I don't know the answer, but he is in the know. He's handled normal trials there, and he's handled all these hearings with Kohberger, so he kind of gets an idea of what the media attention, what the circus is going to be like. And if he doesn't think they're going to have enough security and somebody may get hurt or something crazy may happen, that's not good. Or if the officers get called away and now they're under staffed as far as security goes, that's not good either. So I'm starting to get where he's coming from here. But again, people are probably going to be mad in the community because I don't really know. And if they're feeling like he's saying these people can't do their job and these jurors can't be honest, and this is the community it happened to, and that's why we have trials here. Again, if we wanted people that had nothing to do with the case and had never heard of it and, aren't connected to the community because of loyalty and justice they may feel, then the current system would not be set up the way it is. That's the exact inverse of how it's set up. It's set up as those are the exact people that make these decisions because it affects their lives. They are connected, and it's a jury of their peers. All right, what's his next point about the convenience and how Latah County can deal with it? Well, similarly, Latah County does not have enough court clerks to efficiently manage the jury selection process. It is anticipated that general qualification questions will need to be sent out to 6,000 individuals. That's a lot. But I could also understand why you may ask, if Latah County has 15,000 good ones and we only need 6, why do we need 200,000? That's 194,000 people that aren't ever going to be summoned. 9,000 people that aren't going to be summoned. By the way, within this 6,000, there are going to be some people that do already think he's guilty. So we got to weed them out. But when you're talking about comparing 15 to 200, that's a good argument. That's a big difference. 200 is a lot more than 12 or 15,000. But if all you need 6, can understand the argument going both ways. Court clerks will be tasked with then entering jury information from those 6,000 individuals into an electronic system. It is a lot of work, no doubt about that. This task alone will require several clerks and will take time. Latah County has only one court clerk currently familiar with the process, and she has several other day-to-day responsibilities outside of her role as jury commissioner. That would be tough. Thus, to accomplish the task, Latah County would have to bring in clerks from other counties to help, which again is possible, along with extra computer equipment for those clerks to perform their work. After the initial process, the court would summon in some 1,800 individuals to fill out extensive juror questionnaires. Again, this process would require both court clerks and court security to take attendance, manage, and move individuals where they need to go to fill out questionnaires in privacy, scan questionnaires, and quickly get the questionnaires to the court and counsel. Yeah, this stuff has to happen like that because we need to have all of it as lawyers. My guess is if I was them, it could take overnight even to make sure the lawyers have time to go through all these. Again, while Latah County court staff are willing to do what needs to be done, the reality is that we do not have enough individuals to perform the task of jury selection effectively and efficiently. And he says we, because he's got other cases and other trials and stuff too. So if this is going to be a huge clog and nothing else is going to happen for 3 months and they can go to Ada County and it can just be put into the machine and everything keeps going like business as usual, you got to start to understand that. I realize it's not perfect, but I mean, to ask Becky Hill what a big deal this is, right? And how much of the spotlight can come from this for the clerk. Further, the Latah County courthouse itself poses significant issues for a trial of this length and magnitude. The courthouse lacks the space needed by both the state and the defense. While the state has a dedicated space within the courthouse, the state would need to be faced with the challenge of escorting sensitive witnesses through public spaces in the courthouse to get to the courtroom. Is that going to be different in Ada County? Meanwhile, the defense does not have a dedicated space within the courthouse, and there are limited options available. The few options available i.e. the district court meeting room or pretrial room, are small, located in public areas, are not soundproof. They have soundproof rooms for defense attorneys in the Ada County Courthouse, if it goes there. These locations do not provide the defense the privacy it needs during trial to meet with each other and witnesses. Further, the jury room itself is problematic in terms of size. Fitting 12 to 13 juries in the room for a routine trial is crowded. Fitting 18 for 3 months would be uncomfortable at best. And again, we think back to all this experience we have with these high-profile cases. Murdaugh, people were asking why they're in 2 jury rooms. My guess is if they would have done the trial here, they would have had to split up into 2 jury rooms. Additionally, the door between the jury room and the courtroom is not soundproof. Further, the court security would be tasked with trying to bring the jury into the courthouse in a fashion that ensured the jurors' privacy while also ensuring the court's privacy. The only options for bringing the jury into the courtroom is through the public hallway or directly past the court's chambers. Neither are good options. Further, there is also the issue of the continuing day-to-day operations in Latah County Courthouse. The magistrate judge will continue to have daily hearings. The district judge will continue with the day-to-day operations of the district court, and the juvenile and CPS caseloads will have to continue. Additionally, the clerk's office must continue with its day-to-day operations of processing case filings, taking payments, and assisting the public. All these normal court operations will undoubtedly be strained by the resources required from this trial in terms of space and personnel. So, and I have to say, huge cases with huge publicity in small counties, that's why we allow change of venue. So that's why this is the exception, not the rule, but this case, literally, this judge is saying is the exception. While traveling to another county for 3 months is indeed inconvenient, okay, he admits it here, is inconvenient for the attorneys, the court, some family members of the victims, all family members of the victims, and some witnesses. Having the trial in Latah County Courthouse would also be convenient in numerous ways, and beyond that, would present serious safety risks. Thus, the interest of justice requires that the trial be moved to a venue with the resources, both in terms of personnel and space, necessary to effectively and efficiently handle a trial of this magnitude and length so that the parties in the court can focus on the case and not on the peripheral issues. Adam says, I'm an attorney and it's inexcusable that it takes years for a case like this to go to trial. It's ridiculous. It literally takes courts months to decide a simple motion. I wish everything moved faster too, Adam. I absolutely wish everything moved faster. House being demolished no longer matters. Theoretically, they still could have done a jury view and just bust them over a couple hours, but it's definitely not going to matter. Do you think Dr. Catherine Ramsland will be called as a witness based on her expertise and or relationship with Kohberger by either side? I don't know. I don't know who's going to be called. Honestly, I don't know who's going to be called. So then is it broken down by size of community? Thoughts? I respect it. I think it's size, period. Size of the courthouse, clerk staff, law enforcement, community, potential juror pool. This is just too big of a case and too small of a pond, is what it feels like the judge is saying. Pantuffle, lack of adequate security and staffing would have been a problem all along. He should have moved it sooner then, would have wasted valuable time with another judge. Oh, Pantuffle. What a comment this is for what I have coming later. Everybody remember Pantuffle said this. All right, last paragraph here. Kohberger's motion to change venue is granted pursuant to Idaho Criminal Rule 21A and B. Consistent with the language, and pay attention here, okay, especially if Court TV or somebody else is saying he's not going to leave the case. Consistent with the language in Idaho Criminal Rule 21C2B. 21C2B, remember that because I'm going to pull it up. This court orders a transfer of venue, and this is in quotation, without specifying the new place of venue, and refers the case to the administrative director of the courts for assignment by the Supreme Court to a court of proper venue in another judicial district and an assignment of a specific judge to preside in the criminal proceeding. Theoretically, I guess they could appoint him, but he uses very specific language and cites a specific paragraph of the statute. So let's take a look at that paragraph now, so we can know exactly what that means and why he chose that language and that paragraph. All right, I'm looking at the document still. It is 21C2B. This is Rule 21. This is paragraph C. This is number 2. And this is capital B. We're going to read capital A. Let's read it all, but this is the big one, okay? Transferred to a different judicial district. If the proceeding is transferred to a court of proper venue in a different judicial district, a new presiding judge is assigned as follows. A, paragraph A, which he did not cite. If the original judge desires to continue the assignment over the case, the judge may so indicate in the order, suggesting a court of proper venue and refer to the administrative director of the courts for assignment by the Supreme Court to a court of proper venue and for an assignment of a specific judge to preside. So what does that mean? That means I want to stay on the case, judge, Supreme Court judges. I think Ada County is appropriate as the biggest county. So can you please do your work and assign me and move the case to Ada County? This is what Judge Boyce did for Vallow and Daybell when it got moved to Ada County, each one of those. But this is not what Judge decided to do. He cited paragraph B. If the original judge does not desire to continue the assignment over the case, the judge must enter an order transferring the case. And what are these words here? Because I'm looking at the document still at the same time, the judge's order. He put it in quotes without specifying the new place of venue. In quotes. You want to make sure you got this right. And then what's he supposed to do? He's supposed to refer the case to the administrative director of the courts for assignment by the Supreme Court to a court of proper venue in another judicial district and assignment of a specific judge to preside in the criminal proceedings. He literally copy and pasted that language into his order. So what does this mean, folks? This is Judge washing his hands of the Bryan Kohberger case. He's out. He's like, I'm done. Now, why did he do this? I don't know. Maybe he thinks a different judge would do a better job. Maybe he thinks he's got a full caseload that if he keeps this case, he won't be able to handle his other full caseload, and it'll make everybody upside down and underwater in Latah County. Maybe this case was keeping him up nights and weekends with these immediate motions, emergency motions, hearings. We need a decision today, Judge. Maybe the media attention was too much. Maybe the pressure was too much. I don't know. I'm not saying that is. I'm not accusing him of anything. I'm not saying he's weak or he bailed out. All I'm saying is this was his decision. If the original judge does not desire to stay on, which means he desires to get off the case. Now, theoretically, I think there are some scenarios where he could still be appointed, and the Supreme Court's like, we can't waste judicial resources having a different judge try to catch up. Very, very, very unlikely that happens. Citing paragraph B with that specific language indicates to me that Judge John Judge no longer desires to be on this case. It's one thing to be assigned it when it's in your county, but when you get given an opportunity to bow out gracefully, he took it. And that's within his right, within his prerogative. That's exactly within his discretion, as this rule says. If it wasn't fair or wasn't appropriate, we would not allow it as lawyers when we write these rules. But this rule allows it, and that is the reason. Everybody's like, why is there a new judge? Why is John? I thought you said it was going to be the same judge. I thought it was going to be the same judge. Normally, judges go with big cases that they've had forever. And sometimes, people accuse judges of wanting the fame. Can't accuse John Judge of that. Right? He's definitely not trying to ride his 15 minutes of fame. I don't know why. Maybe I think, if I had to guess, based on his other actions in this case, he just thinks it would be better off for some reason for another case to have this case, which either means he's got to get back to his caseload, and maybe a judge with a smaller caseload or a special judge or something like that everything would run smoothly for the justice system as a whole in Idaho. That would be my guess. There's a lot of different reasons this could happen. Ann Bell said, JJ wants to get off the merry-go-round and away from the circus. You can't really blame him either, right? I mean, he didn't choose it, but we need judges. We need the justice system to roll. He's been on this case. And my opinion is that he is the one most familiar with this case. And it's not that another judge can't get up to speed, but it is going to take time. The lawyers are going to have to do a lot of work getting a new judge up to speed, but it looks like that's exactly what's going to happen. People are saying maybe he's going to retire. Sure, maybe he is. I don't know. All right. And people are saying he's from that area, so maybe he didn't even want the appearance of impropriety. I would respect that as well. All right. The last thing that I wanted to bring up is a statement from the Gonsalves family. Bryan Enton posted this on his Twitter/X, whatever we're calling it these days. But I want to pull it up here because I found it to be pretty interesting. I didn't know this personally. I don't speak to the families. I don't know if it was a surprise to Bryan Enton, but here is a text stating the Gonsalves family statement. The family is incredibly disappointed in the judge's ruling granting the change of venue. The only good thing about this decision is it will be Judge's last decision in the case. In case anybody wondered how the Gonsalves family felt about Judge, that leaves nothing to the imagination. And here's what I'll say about that. Totally fine for a victim's family to feel that way. I've had plenty of victims' families that feel that way about judges. And they tell me all the time. And I get it. And it's something we got to deal with. Sometimes I say it about prosecutor, defense lawyer, whatever it may be. And I get it and we deal with it. This case isn't over. And there's going to be another judge on the case. So if it was up to me, I would probably say I get that you feel that way. And if we are happy about that as a family and, representation for the family, great. So let's move on and hopefully we get a judge we like better. But I probably wouldn't say it publicly because the other judge is going to read that too. And just like, cops stick together, lawyers stick together, judges stick together, not always, but generally speaking, if they know another judge, they respect or like another judge, somebody comes out and takes a shot at that judge, usually it's not going to make them feel good as the new judge on a case or the new lawyer on a case or whatever it may be. So I respect it. They absolutely have that right. Doesn't surprise me when you're going through times like this and everything seems so unfair and so hard and the delays and, the stuff they're going to mention here that Kohberger gets to do. I get it. I get why they feel that way. And the justice system is incredibly difficult and feels completely unfair for victims so many times. So I get that. But just strategically speaking, I want the judge to like me, right? As a lawyer, as a victim, that's not the most important thing, but it still is important. And I do everything I can to stay in the good graces of a judge. Doesn't mean you can't disagree with them. Doesn't mean you can't argue. Doesn't mean you can't fight for your client. Doesn't mean you can't get loud sometimes. But when you have opportunities to build goodwill, I usually take it. The family has always felt that Judge favored the defense. And it was a common theme that whatever the defense wanted or needed, they got. That's how they feel. I think the defense won a lot in this case. Definitely not everything. But I get where they're coming from because the defense does feel like they're winning a lot. Is that the judge's fault? Well, they have another comment on that. The written decision is even more informative. If the judge knew Latah County could not handle this trial for safety reasons, not enough court clerks, logistics, and lacking space, why did he waste over a year in a county he knew was not going to handle the trial? Why did we waste? Sorry. In a county he knew couldn't handle the trial. And that's the interesting part of his decision, right? Because he said, yeah, presumed prejudice, which he didn't know until the defense presented all of that. But all the logistics he did know. Maybe he just didn't know quite how big it was going to be. That's potentially a reason. But we'll see. We'll see. The points he mentioned didn't all of a sudden jump up and bite him in the rear. Okay. Another issue was the poor cross-examination by the state of the defense expert witnesses. A judge can only rely on the evidence presented, and when you don't properly cross-examine expert witnesses or present any of your own, you are left relying on the opinions of the defense. So there they come out and take shots at the state. Again, fair game. The victims are allowed to do this in the case, and they haven't hidden some of their displeasure with law enforcement, the investigation, the state, the way that they prosecuted the case. But it's not all on the judge, right? And the judge even mentioned The state called no witnesses and presented no evidence. He mentioned that in his order, and the victim say it in this case. By the way, Pantuffle, call back to that comment about already knowing all this and wasting time. The victims felt the same way. Then let's not forget the massive contradiction of having a University of Idaho employee as an expert witness, Eliza Cover, and the same time allowing Scott Green, the University of Idaho president, to write a book claiming to be an integral part of your investigation. That didn't help either. So, I mean, the Gonzalez family, I'll tell you, through their anger, through their grief, you can't even understand what they're going through, they're balanced. Like they still have some balance in them, which I can't say I would be the same if I was in their shoes, right? If I was going to understand anybody being not balanced or not fair, it would be them. But they're like, we get it. It's annoying, Judge. We wish you would have done this before. We're glad you're out. But we also kind of get it based on the way the state has run the ball so far. University of Idaho writing books, saying they're integral parts. Well, now everybody connected to the school should be struck. And now where are we? Now we got to change venue. So they get it. They're smart. Finally, what was the point of the non-dissemination order, private hearings, closed-door tactics, allowing the defendant to be dressed in a suit for every televised hearing, etc., if not to keep the trial in Latah County? He's got a point there. But sometimes that's still not enough. As victims of families, you are left to just watch like everyone else, and really you have little rights or say in the process, and at the same time, you are the most vested in the outcome. We have always felt that a fair and impartial jury could be found in Latah County, and still believe that is where the trial deserves to be held to help the community heal. Thank you again for all your support and prayers. He doesn't even mention the fact that they got to drive hours, they got to stay in hotels. He's not thinking about himself. He's not thinking about how annoying or difficult it could be, which frankly, I would, if I was representing him and made a comment, that's what I would say. Sucks for them. It's even harder on them, makes their life even more miserable in the most miserable time ever of their life. Reliving and rehashing and going through the most miserable day of their entire family's life. He didn't even come out with that stuff, which I think would have also been warranted and fair game. So overall, they are not happy about the change of venue, but seems like they're happy to get a different judge instead of Judge John Judge. A lot of new information coming out, a lot to deal with in this case. Can JJ make a statement once they appoint a new judge? I don't think that would be wise. Can he? I guess. I mean, there's a non-dissemination order, so he would definitely not want to violate his own order. If he was going to comment, he would just say, yeah, that's the ruling I made, or it's all in the papers. I can't imagine he would comment with any color. John, I wouldn't want to be in the shoes of Elizabeth Scheer. Tough position. I think his community is too small, in my opinion. I don't know. Yeah, I mean, we saw how it is, affecting her community, her state attorneys she worked with, people she knew. But the judges know a lot of people in every trial. So it's part of their job. And that's why it's not an easy job. What is the difference between a jury of peers like education, wealth, culture? Curious because change of venue in Rodney King case from LA to Simi County. Thanks for 2 lives today. So jury of your peers just means people similar to you. Doesn't have to be the same exact age. Doesn't have to be the same exact race, same job, socioeconomic. Doesn't have to be the same of anything. But it's people in your community that you do life with. If you were to walk outside and just look at who all the people are around you, doesn't mean your best friends, doesn't mean your worst enemies, but who the people are around you, that's generally who it should be. All right. That was most of the seriousness of this. There's a couple other questions that are kind of one-offs I'm going to answer now. So if you guys are going to leave, hit that like button, please. 2 lives today. Make sure you subscribe. Let me know what you think. John, why don't you put up, before you guys leave, answer this poll question. After hearing the court's reasoning, do you agree with his decision, yes or no? Throw that poll up while I answer these questions, and we'll talk about the results after. As a fellow Tesla guy, have you reviewed the new FSD 12.5 or the summon feature? Not an important question, but I had to ask, maybe save for last. So not completely last, but close to last. I have not. I've only had self-driving for a month here and a month there. I don't personally love it. It freaks me out. I like the auto steer where it's in one lane. So I've kind of gone back and forth on full self-drive. Sometimes I'll get it before I take a trip to Tallahassee or something, which I might do here. I'm going to Tallahassee in a couple weeks for a game. I don't want to talk about it. But I haven't. Have you? If you have, let me know how it is. Reese's mom, way off topic. I've never heard of pickleball before you. Now I heard about it all the time. Have you seen the E-Trade commercials with the adorable toddlers playing? Yes, I have. And I might be doing a little deal with a pickleball company. I'm going to try out their paddle and some of their gear here. They're going to send me some stuff. So I may be talking about it, and we may have a discount code for anybody that wants to like try it out. So you can get a discounted, cheaper paddle maybe. They have all different levels, high, mid, low, as far as price. If you want to check them out and there's somebody that, supports our channel, if you guys want to support them, that's something that might be coming soon. We're in talks, as they say. Reese's mom, Halloween, Will Ferrell as Ron Burgundy. Oh, that's good. The number one thing I think of myself, which may be kind of weird when I do this mustache thing, is Jack Pearson from This Is Us. I only watched like the first 2 or 3 seasons, but I was like, whoa, like looking in the mirror and seeing him because he had long black hair and a black mustache. That's why my brother-in-law is like Ted Lasso. I'm like, Ted Lasso, like literally all we have in common is a mustache. Nothing else is the same. Rebecca beat Peter, albeit by a hair in fantasy this week. Come on, Rebecca. Come on. You didn't beat me. You may have outscored me, but we were not matched up. You got to save that for when we're matched up. We'll see who comes out on top when we're matched up. Nobody cares how many points you score against somebody else. You got to come do it against me. So we'll see. I think I won this week. It's not over, but pretty sure we're both going to win this week. I'm going to be 1-0. Just survive in advance, 1 win at a time. That's my fantasy mantra because everything can change in fantasy very quickly. John, is the poll up? Endorsing Tesla, legal nightmare. Sorry, I'm not sure you understand how endorsing works. That's not how it works. I have a Tesla. I like my Tesla a lot. And that's as far as it is. All right, here we go. John's giving me the results. 79%, almost 80% of people agree with the court's ruling. And after you hear a court's reasoning, after you read 20 pages of what a court has to say and why he made the decision, it makes sense to agree, but not everybody does. Still 20% don't agree. So that's interesting. I love it when you guys answer poll questions. I love it when you give comments. I learn so much from it. And you're seeing, I'm not just blowing smoke when I say how important your guys' opinions are to me. Like the 7,000 or 8,000 of you that were in this chat, he went and interviewed a couple hundred people and made a real difference in a case what those couple hundred local people think. Well, I get to get all this information from you guys, thousands of people from around the country, even some around the world, usually in the high 80 percentile or in the United States, to help learn how this stuff works. It affects our cases. It affects those of you who become my clients one day, right? We do car accidents, trip and falls, truck accident cases, wrongful death cases. A lot of you guys have funny names for PI lawyers, and I get it. There are some annoying, scummy, frivolous PI lawyers, but your information helps if you one day become a client of ours. So, I mean, that's cool to me how this all goes for full circle, helps the community, does good for all. So again, I appreciate it always. I appreciate you guys. I appreciate you guys when you have those issues. We're happy to help. It's what we specialize in. It's what I focus on. It's what I try to become an expert at, is those kinds of personal injury cases and wrongful death cases. And you guys literally help with that. That's why like more lawyer organizations ask me to speak now than ever before. And most of that is because of you guys and the knowledge I gain because of what you guys have to say and your input on this channel. So public service announcement there. All right. That's all we got. Till next time, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.